Thank you very much, Ranking Member Leahy, and thank you for having this hearing. And I must say there is a lot of history and wisdom and insight and eloquence on this panel, and I'm deeply respectful of each of you for your public service to our nation. But if I may say so, you're no substitute for the real thing.
We understand.
I think you would agree.
We agree.
And this hearing is no substitute for the real thing. We should be talking not about the damage to our justice system, the results from the refusal to have a hearing and a vote, but about the qualifications of Judge Merrick Garland with Judge Merrick Garland in the place where you are sitting now. That's what the American people deserve. And I think, Judge Lewis, you made a very telling point that there is damage to the court and to our justice system from the politicization, dragging the court into the mire of partisan bickering, which has infected this place, much to the consternation of the American people. I was a law clerk to Justice Harry Blackmun, and then U.S. Attorney and Attorney General of our state, and I've argued 4 cases before the United States Supreme Court, and I have a deep respect and reverence for our judicial institutions. They should be above politics. And I am deeply saddened by the, in effect, polarization politically of views on the confirmation process and the refusal of our colleagues on the other side to do the right thing and to do their job and instead to obstruct this process. And I think the effect is not only 4-4 deadlocks, but to use the very apt phrasing that you cited from the New York Times article this morning, the court is not so much deadlocked as diminished, because the effect is not only to fail to resolve splits in the circuits, but also to duck issues, as they did in the ruling in Zubik, and also to fail to take cases and resolve them. And I spoke yesterday on the anniversary of Brown v. Board of Education on that anniversary, but also on the effect of the court. And I have no doubt that Brown v. Board would never have been decided unanimously with a 4-4 court. Given the history, and we know more about the history now of what Earl Warren did in that court, the dynamics would have been totally different, and the dynamics now in the court are totally different. And the effect is to marginalize the court, diminish it as a branch of government, which in turn diminishes our democracy. And so I think we owe it to the American people to move forward with a hearing and a vote on a man who has superb, in fact, impeccable credentials. I would like to ask you, Mr. Driver, and I have known Judge Garland for many years. I first met him when I was U.S. Attorney decades ago. When he had a hearing in a case, and I think you mentioned it in the letter that you and other clerks wrote, did he come to the hearing and make a decision based on a predetermined point of view, or was his mind changed by what he heard, what he read, what he exchanged with you, his law clerks?
Yeah. I would describe Judge Garland's attitude and approach toward cases as being very much bottom-up rather than top-down. And by that I mean he does not have some sort of overarching, judicial ideology that he is imposing on the facts of particular cases. Instead, he is committed to reading the binding precedents and the briefs and the record and immersing himself in those materials in order to reach an appropriate outcome. And I think that that is a big part of the reason that he's been so successful at fostering consensus. In addition to his temperament of not sort of demonizing people. I never heard him utter a disparaging word of any of his colleagues on the D.C. Circuit or any other of the lawyers that appeared before him. And so I think that it's not that he sort of had those thoughts and was muting himself. Instead, there's a certain generosity of spirit that one sees with Judge Garland. And so the immersing himself in the materials allows him to identify points of commonality for himself and two other people who were on the panel. And so people should not think that the relative lack of dissents are indicative of someone who's trying to sort of cut a deal or sacrifice his core judicial principles. That's not the case at all. Nevertheless, he is able to identify points of overlap and commonality as an effort to have the court speak as a court rather than three individuals who are just sort of offering their own views. So I think that's why he's been so successful.
And someone who believed most deeply in the rule of law, as he has said.
Yes, absolutely.
Thank you. Thank you, Mr. Chair.